Hey, hello out there. This is Christel Bell, consumer investigator for the Let ABC 15 Note team. Thank you so much for joining us today. We're excited about this topic as we're gearing up for another phone bank that will happen in a couple of weeks. And you got to stay tuned because I will give you the details about that phone bank. But we are talking about employment law. Employment law is what we'll be focused on. And I'm so glad that we have one of our volunteer experts, attorneys, professionals, all of the above, who has been with us before in a phone bank and is joining us again in the coming weeks to be with us to talk about employment law. Matt Moosebrugger of Moosebrugger Law. Did I get
Perfect.
it right? All
Yes.
right. Just
I
want
know
to make
it's a
sure.
tricky
Yeah,
one.
I know, right? Thank you so much for being with us.
Yeah, of course. Thank you for having me.
How you feeling?
I'm feeling good.
Good. I'm glad.
Yeah.
I'm glad. Listen, give the folks out there just a little glimpse of your background and how long you've been practicing employment law.
Yeah, my journey with employment law began in law school. I worked at the Attorney General's office in the Civil Rights Division there, handling matters of employment discrimination, workplace harassment as a law clerk.
Mm,
So back in, wow, 2015, so about 11 years ago.
yeah.
And most of my legal journey has pretty much always been revolving around employment law.
Okay,
Yeah.
wow. So a lot of experience in this. I like to think we really need to understand and know our rights. We all work, and we have to work and to make ends meet. And so, but things happen in the workplace, right? And so that's where you come in. I guess really explain, what does employment law cover? We know we talk about harassment, discrimination, that is. What other topics? What is covered under employment law?
Yeah, employment and labor law is a pretty broad area. It can
Hmm.
go from unemployment benefits, workers' compensation for injured employees on the work or on the job site, matters of employment discrimination, workplace harassment, wage and hour issues, people
Hey,
not being paid overtime or
yeah.
compensated in accordance with state law.
Hmm.
Arizona has sick leave laws that were passed more recently that require employers to actually provide accrued sick leave time. There's quite a few different areas that,
A wide range of things,
yeah,
right?
it
And
is.
so I guess that's important because if you have an issue, it's probably a good idea to kind of consult with an employment law attorney just to kind of see what your rights are and understand because it's such a wide topic of issues.
Yeah, absolutely. I think it's if you think there might be an issue or you might have a claim, it's better to reach out to someone and find out for sure,
Mhm.
rather than not address it.
Yeah. So I guess when you say when a person feels like they have some type of issue, what do they need to come? What documentation do you typically look for when they possibly may have a claim or they have an issue, concern? It's always that burden of proof, right? So what
Absolutely.
documentation do you typically look for when they come to you?
Yeah, it really depends on the particular issue. I handle a lot of employment discrimination, workplace harassment, and retaliation matters. So, for example, like a retaliation claim, retaliation is unlawful for someone who engaged in protected activity, which is reporting concerns of discrimination or harassment based on their membership in a protected class like race, color, religion, sex, age, national origin, or disability. If you report concerns about being treated differently based on one of those protected classes or being subject to a hostile work environment because of your membership in one of those protected classes, that's protected activity under both state and federal law. So if all of a sudden an employer then retaliates against you, terminates you or something because you did that, then you've got a strong retaliation claim. Some of the things that you're going to need to prove, though, is that you actually engaged in the protected activity.
Mm,
So, typically I advise people to always do that in writing,
mhm,
via email or, you know, and then keep a copy for yourself. Because
mhm.
obviously, if you get terminated, your employer is going to cut off your email access immediately, and you
Right.
may not have access to that email that proves that you engaged in that protected activity.
Mhm,
So things like that are very important to do in writing and keep copies for your own records.
mhm.
That's definitely some important evidence for those type of claims.
Yeah, can you really briefly talk about too, because when you were talking about that, I thought about what are the laws with understanding when you may go into an office and have to record a conversation or have that recording device to give you that proof that something inappropriate has happened? What are your rights?
Yeah, so that's a tricky one because Arizona is a single party consent jurisdiction. So only one person has to consent to recording a conversation, and
Hmm.
it can be the person making the recording.
Hmm.
So that's not unlawful, but a lot of employers will have a policy against recording conversations. And so then all of a sudden, if you violate their policy and you give them an independent reason to take an adverse employment action against you, then that's where it gets a little tricky. So
Hmm.
if your employer has a policy against it, that can give them an independent justification to terminate you or reprimand you or something,
Wow, that is
even though it's not
tricky.
unlawful.
Yeah, that is tricky. Wow.
Yeah.
Okay, so how do you handle inappropriate behavior from a coworker or supervisor? What should we know?
Yeah, so employers are required to provide a hostile free work environment based on those protected classes. General bullying and being mean at work is not technically unlawful
What?
unless it involves a protected class.
Okay,
So,
gotcha.
if you're targeting someone and harassing them based on their race, color, religion, sex, age, national origin, disability, I know it's a long list, but they're important protected groups that provide employment protections at the state and federal level. And the employer's obligation begins when they're made aware of it. So if it's a coworker that's bullying someone based on, one of those protected classes and the employee reports it, one, they engage in protected activity by reporting it. And
Hmm.
then two, the employer is obligated to provide a hostile free work environment moving forward once they're made aware of it.
Should you immediately go to HR?
Yeah, so most employers, particularly larger employers, will have policies and procedures to how they handle those things. Usually, it's a human resources official who takes that complaint or something, but just making any member of management aware of it is what satisfies the employer's obligation to take action.
Hmm.
So managers have mandatory obligations once they're made aware of these things to bring it to the proper individual.
Okay, all righty. Will you give some examples or just some things that you've heard as far as what constitutes as discrimination in the workplace? You've given those groups, you've listed those, and list them again, and just kind of explain kind of what does discrimination look like? Because a lot of times people may not be aware that that's discrimination.
Absolutely.
Yeah.
Yeah, it can take many different forms. Things like not making reasonable accommodations for individuals' sincerely held religious beliefs or disabilities is considered discrimination. Subjecting someone to severe and pervasive harassment based on one of those protected classes is considered discrimination. Or, taking adverse employment action like termination, demotion to a lower paying job, or suspension without pay because of their membership in one of those protected classes or in retaliation for
Mm-hmm.
them engaging in protected activity is also considered unlawful discrimination. So it's quite a wide range of things that can be considered technically discrimination.
Yeah.
And they're all important for employees to know about because that's how they're better informed employees know their rights
Yeah.
are gonna hold employers accountable and lead to a better working environment for everyone.
Yeah, I agree. So kind of talk a little bit about we know that we have another thing as far as workman's compensation. What is kind of Arizona's laws as far as navigating through workers' comp?
Yeah, so that's another thing that's actually considered protected activity is
Hmm.
invoking your rights under workman's comp. So an employer can't retaliate against you for doing that. But generally speaking, if you're injured on the job, you have rights to be compensated for that period of time where you may not be able to work, or you're maybe you have to shift to a light duty assignment or something. Say you're doing manual labor, but you have an injury, and then all of a sudden you're not able to perform that job responsibility. If it qualifies as a disability, employers are required to provide accommodations, which could mean a change in assignments, shift to maybe a lighter duty
Hmm.
while you're recovering, things like that. They have a lot of obligations under state and federal law.
Hmm.
And so, a lot of employers will have workman's comp insurance, and then they'll have you dealing with, a third party company.
Hmm.
And it can be tricky to navigate. So it's definitely
Yeah.
important to, if you are injured on the job, to contact an employment attorney.
And Matt, what do you do in situations where your claim is denied because we've seen that happen, often, and denied because of, whatever reason they give. How do you appeal? Do you continue to appeal? Like, what do you do? Because that's difficult as the bills are stacking up, right?
Certainly. Yeah, it's important to work with a good workman's comp attorney to pursue an appeal. It's not something I personally handle at my practice, but
Okay.
there are a lot of very good workman's comp attorneys in the Valley. And a lot of them specifically will handle that issue alone. They
Mhm.
don't do the whole gambit of other employment law areas. A lot of them are
Okay.
very specialized in
Okay.
workman's comp. And when people come to me with those issues, it's important to have a good Rolodex of good workman's comp attorneys to refer them to.
Absolutely. Alrighty. So let's talk about what are state laws as far as overtime pay. We've heard from LAK viewers who say, "Hey, my employer is not paying me overtime. What are their rights? What should they know?"
Yeah, that's a violation of Arizona's wage laws. If you're working over 40 hours a week, you are entitled to be compensated for that overtime at the higher rate of pay that they're required to. And if an employer is not doing that, there's a state agency called the Industrial Commission of Arizona,
Hmm.
and they handle wage issues at the state level. So
Hmm.
they're an administrative agency. You can obviously have, pursue a lawsuit for those violations. But I typically recommend people try to take advantage of the administrative resources that are available because a lot of times it can lead to a quicker resolution
Yeah.
than having to fight a lawsuit and spend a bunch of money.
Right.
So the Industrial Commission of Arizona is a state agency that's funded by our tax dollars, and anybody can avail themselves to the services that they provide, which they do a great job of investigating wage issues such as failure to pay overtime. They also handle sick leave matters. They're also sort of our state whistleblower retaliation branch. So the Industrial Commission of Arizona is certainly an important resource for people to know about.
For sure. You mentioned we talked a little bit about discrimination, but for folks who may not understand, discrimination and harassment are two different things,
So
or do they work?
they're very similar. It's technically under the law. If someone's subject to a hostile work environment
Hmm.
that's severe and pervasive conduct based on their
Hmm.
membership in a protected class, it's technically discrimination
Hmm.
because discrimination not only prevents employers from taking adverse actions like termination against someone for that reason, but they also have to provide hostile free work environment. It's the same state and federal laws that cover both.
Okay. Okay. And is that also a matter of going to the administration as well to file reports when those situations happen rather than first going to an attorney? Should they file?
Yeah, so it's definitely whether you're going to go the administrative route or not, it's certainly important to consult with an attorney, particularly on matters of discrimination and harassment. They're a unique area of law where you can't just go file a lawsuit in state or federal court. You have to exhaust what are called your administrative remedies first
Hmm.
and receive what's called a notice of right to sue.
Hmm.
So, unlike most areas of law where you can just go straight to court and file a lawsuit, you have to receive that document first. And it's really an effort to try to get these matters resolved before they end up in a lawsuit. So, an attorney can assist you with filing a charge of discrimination, either with the Civil Rights Division of the Attorney General's office here in Arizona, or with the Equal Employment Opportunity Commission,
Hmm.
which is the federal arm that enforces the federal anti-discrimination laws, whereas the Attorney General's office enforces the mirror image same laws at the state level.
Hmm. When you talk about employment law and all of the things that it entails, there has to be a level of fear because you feel like I'm this little person going up against this bigger company. What do you say? Because there are a lot of times people won't speak up because I need this job, I need this money, so I have to endure. What do you say?
Yeah, it's unfortunate that a lot of times the remedy is retroactive, right? You suffer an injustice or someone violates your rights, and you have to go through a period where you're struggling or things are made more
Hmm.
difficult than they have to be because
Hmm.
of something outside of your control. And it's unfortunate, but it's incredibly important to keep good records. Like I mentioned, document everything that you think is potentially evidence or could support your claim.
Yeah.
And then, speak with an attorney about how to actually hold them accountable. Because when employees know their rights and they hold their employer accountable, employers are more likely to not make the same mistake again in the future. And so you're not only getting justice for yourself, but you're hopefully helping to prevent future injustice as well.
Yeah. Can we talk about leave? We know that there are different leaves. FMLA leave, we've seen, people can leave for mental health issues. What should people understand about that, in understanding their rights when they ask for leave?
Yeah, so FMLA one is one that we see a lot of issues with. Employers don't always know their obligations to provide FMLA leave, which, for those that don't know, the Family and Medical Leave Act is a federal law that provides up to 12 weeks of unpaid time off of work. If you've worked for the employer for over a year, and in that previous year you worked more than 1,250 hours, you're eligible to take that 12 weeks off, and your employer can't, terminate you. They can't fill your position and not bring you back to the same role, or demote you or something like that. That's all considered FMLA retaliation. There's also another common claim called FMLA interference, where you need this time off for a qualifying medical reason or to care for a family member even. And then while you're on that time off, they're constantly bombarding you with emails and trying to get you to do work while you're
No,
on
no,
that protected
no.
time.
Right?
And so
No.
that's a violation of the Family and Medical Leave Act as well that we see pretty often.
Wow. You see that often?
Unfortunately, yeah, people don't understand well, many do, but some employers don't realize that that protected time off is truly protected and that they can't interfere with it.
Gotcha. Gotcha. What is the one thing you feel like working in Arizona, employees and businesses, companies, what should employees truly know and understand when it comes to their rights?
Yeah, it's certainly important to know that even though we're in a state where employers can terminate an employee for any reason or no reason at all, you still have rights because they can't terminate you for an unlawful reason. And the most common unlawful reasons are because of your membership in a protected class, in retaliation for engaging in protected activity, or in breach of a employment agreement. That's the one way around our at-will employment status in Arizona is if you have a valid employment contract that says that an employer can only terminate you for certain reasons or for cause, then that could lead to a potential breach of contract claim as well.
Absolutely. Gosh, that's great stuff. Okay, so I wanted to give you a couple of examples of some of the things that we've heard from. Again, let ABC 15 know viewers who are concerned. We've heard from employees who claim that their employers are requiring them to work off the clock without compensation. What are their first steps to taking action to fix this? What should they do?
If in that circumstance, that is a perfect example of why someone would contact the Industrial Commission of Arizona, because that is a violation of Arizona's wage laws. So, if you're working, you deserve to be compensated for that time. And if your employer is failing to do that, then that's exactly the type of matter that the Industrial Commission of Arizona investigates and takes corrective action to address.
How many times does a person should, if you make a complaint after complaint, and you're feeling like no one's hearing me? We often see those situations as well. At what point do you say, okay, they're not listening to me. I need to move and go to the next step?
Yeah, absolutely. I think that particularly when it comes to matters of workplace harassment or a hostile work environment that someone's experiencing. If you've made your employer aware of it and they're just not taking any corrective action, they haven't even looked into the matter or tried to, provide relief from the hostile work environment that you're experiencing, then you would want to contact an employment attorney and discuss, taking formal steps to force them to address it. And that can be a short process, or it can be a lengthy one. Going through the full administrative process with the Attorney General's office or the Equal Employment Opportunity Commission can unfortunately take years. But you can also have an attorney reach out to the employer's counsel and try to get it resolved a little bit quicker and more effectively or efficiently, to hopefully provide redress from that hostile work environment, so you don't feel like you're compelled to resign or seek employment elsewhere.
Yeah. Okay. Okay. Here's another one we saw from one of our Let A BC 15 No viewers that says um, they are claiming that their employer, this is service industry, restaurant, um, the employer keeping tips from workers. How do you handle this?
Yeah, this is another wage issue that violates Arizona state law. And
Hmm.
it's similarly, the Industrial Commission of Arizona
Hmm.
investigates and addresses these matters as well.
Hmm.
That certainly shouldn't be the case. Members of management and ownership who are on salary or, they're not allowed to participate in tip pools or withhold,
Hmm.
uh, you know, service workers' tips.
Okay, gotcha. What are you seeing? What are the calls that you're getting into your office, and what kind of cases are you handling now?
So I do a lot of employment discrimination and
Hmm.
workplace harassment cases, and I represent private sector and public sector employees in Arizona, and I also represent federal employees nationwide. We
Wow.
have a pretty large presence of federal employees in Arizona. A lot of them work at the Veterans Department of Veterans Affairs, the U.S. Postal Service. There's a lot of federal agencies that have a presence in Arizona,
Hmm.
and federal employees have a much different process to address issues of employment discrimination and workplace
Hmm.
harassment, and to receive reasonable accommodations for qualifying disabilities than private sector employees do.
Hmm.
I've been seeing a large influx of federal employee cases.
Hmm.
The administration has issued return to office orders, so people who've been working remotely or being required to return to the office, whether they have a reasonable accommodation for a disability to work
Hmm.
remotely.
Wow.
That's a common reasonable accommodation that a lot of federal employees have, and some of these federal agencies are requiring them to return to the office without taking into consideration the fact that they've got a disability that they're being reasonably accommodated to work remotely.
Oh, wow. Wow. And so then do you feel like it's more larger companies, smaller businesses who may not understand what the laws are, or is it just kind of a mixture?
Yeah, so state and federal anti-discrimination laws, they apply to employers of 15 or more employees. So
Mm-hmm.
unfortunately, there is a small business issue where if you have between, 1 and 14 employees, you're not covered by the laws that prevent discrimination or harassment
Oh,
based
wow.
on race, color, religion, sex, national origin, disability. And for age discrimination, it applies to employers with 20 or more employees. And so, every size of business has these issues,
Mm-hmm.
but the ones who typically have a harder time addressing it are kind of in that middle range. If between 15 and 100 employees, maybe they don't have an in-house general counsel or a robust HR department to address these things when they come up. That being said, the large companies that do have all those things also make mistakes,
Right.
and they're
Right.
so it's not like any business is perfect or any employer is perfect, but there's certainly these similar issues
Yeah.
run the range of
So let's
sizes.
go back because you mentioned something that's very interesting. So those companies that have 1 to 14 employees, they don't have the same protections. What are their rights? Do they have any rights?
Yeah. So one thing that applies to all employers, whether they have one employee or 100, is sexual harassment laws. So
Okay.
sexual harassment is unlawful regardless of the size of the company. But unfortunately, if the employer doesn't have 20 or more employees, then the age discrimination is not technically unlawful. And if they don't have 15 or more employees, then discrimination based on those other protected classes isn't technically unlawful.
Wow.
Yeah.
Laws need to change, that sounds like.
Yeah, that's one for the legislature and
Yeah.
for Congress
It
to
sounds
address.
like it. Yeah, absolutely. I want to give folks the details about our phone bank that's coming up, but I thank you so much. This has been great, great, great information. And of course, Matt will be with us on Tuesday, May 19th. Our phone bank will happen then. We'll have employment law attorneys like Matt and others who will be answering your calls. If you have questions, you can call in and have those questions answered for free. As you've heard, this gentleman knows his stuff. So you want to call in and speak with him and the other attorneys that will be joining us. So again, that employment phone bank is going to happen Tuesday, May 19th from 5 to 7 p.m. We'll give you that number that you can call. You'll be able to have your questions answered for free. You know, many times it takes something to talk with an attorney, but this is where you can have your questions lined up, have your documents ready, call in and speak to an attorney. We partner with the State Bar of Arizona to host this phone bank to give these resources to you for free. So again, mark your calendar. It's going to happen Tuesday, May 19th from 5 to 7 p.m. We'll give you the number to call before the phone lines open. They'll go until 7 o'clock tonight, where you can have your questions about employment law answered for free. Matt, thank you so much for being with us. We certainly appreciate it. We look forward to having you with us on May 19th. May 19th from 5 to 7 p.m. But just great information for those folks out there.
Yeah, thank you so much for having me. I'm really looking forward to the phone bank, and hopefully we'll be able to provide some good resources for everyone.
Sure will. We'll do it. All right. We'll see you next time. Take care.